Hey, Attorney Zach Bailey here to talk about a recent trial success we had here in Indiana. A couple days ago, we did a trial on someone who has a CDL, a commercial driver's license. And for these people, an OVWI charge is so serious because any OVWI conviction results in an automatic 1-year suspension of their commercial driver's license, even if it's just their first offense. So he came to us desperate because if he loses this trial, if he pleads guilty, anything like that, he loses that license. That's his livelihood. So the case was in a parking lot. So he was trying to leave the parking lot. Parking lot attendants were worried, so they called the police to come and check out the scene. The police came, did an investigation, took him for a blood draw because they believed they had probable cause to do so. Our client consented to the blood draw. The results of that test were .201. So it seems like an easy win for the state, right? Not necessarily, and this is why we do a full investigation into everything. Because what the state didn't realize was nobody actually saw our client drive the vehicle to that gate. There were civilian witnesses there, but they weren't available for the trial. And the state enjoys what's called a 3-hour presumption, where from the time the person last operates the vehicle till the time of the blood draw or breath test, as long as less than 3 hours have passed from operation to test, the state gets to say whatever those results are what the person's test was when they were operating the vehicle. So if I drive at 7:30 and a blood draw is done at 9:30 that comes back at .15, they can say my blood was .15 when I operated the vehicle. So what we argued was that since nobody saw our client move that vehicle, the state couldn't establish when he last operated the vehicle. They couldn't establish that 3-hour time frame. And we used that to keep the blood results out. Without the blood results, all that were left was one failed field sobriety test, which the officer was sort of new, and there were a few issues with it. We hit on those too. He was looking at his card as he was trying to do the eye test, and he was taking notes. So he's trying to tell us that he was able to do 3 things at once on a highly scientific test. They also said our client had some slurred speech. Well, our client, there's a language barrier with him. Whenever someone's talking in not their native language, there can be some issues with speech. And so we hit on that as well. And at the end of it, the judge issued what's called a directed verdict, a 41B verdict, saying the state did not have enough evidence to proceed with the trial after their case in chief was closed. And we were able to get a not guilty verdict for a very, very, very happy client who's able to keep driving, able to continue with his livelihood. He was so thankful to us, and that's so cool for us to see, a positive impact like that on someone. So if you have any questions about an OVWI case in Indiana, give us a call, 317-632-3642. Remember, always plead the fifth.